Hello and welcome to the Q2 Legal Issues and Regulatory Compliance webinar hosted by the California MBA. Very happy that you could join us today. I'm Susan Milazzo. I'm the CEO of the California MBA, and again, happy you could join us for a great presentation by some great speakers. Before we get to the presentation, I would like to take a moment to thank our sponsor, CDF Labor Law, and I'd like to welcome Ashley Halberta from CDF to say a few words to our attendees. Ashley, I'll turn it over to you.
Thank you, Susan. CDF is proud to sponsor the CMBA in its legal regulatory webinar series. For those who aren't familiar with CDF, we are a California-based labor and employment defense law firm that is located in 5 offices throughout the state. We provide employment-focused legal services, including advice and counseling, as well as litigation. To highlight a few of the things that we do, we defend companies against claims of sexual harassment, unfair competition, wrongful termination, and wage and hour violations. We also provide day-to-day counseling services to compliance strategies to help avoid lawsuits so we can fix things before you get sued. So if you have any questions, feel free to reach out. Thank you.
Thank you so much, and we always are happy to welcome CDF Labor Law to our December Legal Issues and Regulatory Compliance Conference in Southern California. And I know that labor law and employee issues remain top of mind, one of the top of mind issues for lenders. So Ashley and CDF, thank you so much for your support. We appreciate it.
Thank you.
And with that, I'd like to get into our agenda. We have with us the chair of our Mortgage Quality and Compliance Committee, Melissa Kopel with CMG Financial. Melissa, welcome. We also have our Legal Issues Committee co-chair, Gwen Rebar with Wright Finley Zach. Gwen, welcome. If you'd like to participate or join either of those committees, you can contact us at membership@cmba.com and we'll be happy to get you added. And with that, I'd like to welcome today's speakers and get our presentation started. So we have 3 great speakers for us today. First, I'll start off with John Levenick, who's a senior partner at Garris Horn. John is a seasoned lawyer, focuses on consumer finance, capital markets, and technology. He advises clients, heavily regulated clients, in a wide variety of transactions relating to asset purchase, sales agreements, RMBS issuances, information technology, SaaS and cyber security, privacy, and vendor management. So John, welcome to today's presentation. We also have Michael Pfeiffer, who's of counsel at Wiener Brodsky. Michael, of course, serves as our general counsel for the California MBA, and he represents lenders in a wide range of litigation and regulatory compliance matters involving both federal and state mortgage banking financial services laws, including TILA, RESPA, ECOA, FCRA, and UDAP. All of the great acronyms, Michael, you've got them all covered. Good work. And last, I'd like to welcome Genevieve Walser-Jolly, who is a partner at Womble, Bond & Dickinson. Genevieve, her practice includes defending individual and consumer class actions on data privacy, mortgage servicing, TCPA, and auto finance. So speakers, welcome to today's webinar. I believe we are starting off with Michael. So Michael, I will get to, we should have had that slide up there while I was introducing all of you. I will start it off with your presentation. So I will turn it over to you.
Okay, well, I'm going to go through these slides kind of quickly. I have a lot of slides and I don't want people to be intimidated by that, and I want to respect my fellow speakers. So some of them I'll go through quickly because they're less important to the, they're important, but they're less important to the focus of our call today. So so go ahead and click through the next slide, Susan. Next slide. No, go back. Yeah, that's the first. Yeah, there we go. There is a in this area, my responsibility in this webinar is basically to give you a quick overview of some of the privacy laws and regulations. And when I signed up for that, you know, I was like, oh, this should not be difficult. It turned out to be a lot more difficult than I anticipated. There's a lot more when you really get into it. There's a lot more in the way of law and regulations governing privacy and cybersecurity than you can even imagine. There is what I use the word plethora, which I don't think I've used much since law school or in some of the arguments that I've used in court, but of laws and regulations, and some of them conflict. And I've listed them here. These are the major ones. Forgive me if I've overlooked some. I know that I have. There are some that I may not have picked up on this, but these are the major ones that govern what we do and affect our industry with respect to privacy. So I'm going to lay out all of these things, with the exception of one or two of them, strengthen or reinforce the notion of privacy. There's a couple of them that are antithetical to that, or that at least challenge that, and they're opposing to that. So there are constitutional protections. There's provisions in the Fair Credit Reporting Act, the Financial Privacy Act, the Bank Secrecy Act. Even the IRS code has some restrictions and limitations to protect privacy. The Electronic Funds Transfer Act, various computer privacy laws, both state and federal. The Federal Financial Privacy Law, which we'll talk about, and which I think is the core of federal privacy protections for consumers, including their data security standards, state financial privacy laws, and then I'll do some discussion of California privacy and data protection laws, and some legislative initiatives that we're dealing with, and finally some UDAP enforcement. So let me see here. I just clicked a button and took me away from the screen. There we go. That's better. The first layer of protection is constitutional, and it's interesting. The United States Constitution does not have or explicitly state a right of privacy. There is, however, the Fourth Amendment to the Constitution. There's also the Fifth Amendment, the Fourth Amendment, the right of people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures. That's the key part of it. And so that is I guess that's the leading constitutional protection at the federal level. But some state laws have, they also have those kinds of protections. But some state laws, including California, have a constitutional right of privacy. And I've listed the California Constitution, Article 1, Section 1, that goes into that and lays it out, that among these rights, that all people are by nature and free and independent, have inalienable rights. Among them are the right of privacy. So it's enshrined in our state constitution. Next slide. The Fair Credit Reporting Act is, a lot of people don't recognize this, but it is really one of the first significant federal efforts to address privacy and personally identifiable information. Enacted in 1970, it highlights the need to ensure consumer privacy through consumer reporting agencies, and to exercise, quote, their grave responsibilities, which truly they are, with fairness, impartiality, and respect for the consumer's right of privacy. There are standards that are established, which we all deal with, for collection and maintenance of credit and other data by the reporting agencies, and it does give consumers the right to have access to and to correct the information in their files, and to have summaries of their disputes with the reporting agencies and disseminated to recipients, so that there is an interaction that's built into the statute with respect to the sharing of privacy rights and private information. Restricts the dissemination of consumer reports to permissible purposes and to permissible people. Basically, you have to have a legitimate reason to access some of the information, and also prohibits the disclosure of obsolete or inaccurate information. And then there are civil and criminal penalties associated with it. So again, these are all of the presentations I've given in these statutes today are pretty high-level presentations. They're a lot more complex than what you're going to get. If we were to do that, you'd be listening to me for probably 3 or 4 days. And 15 minutes is probably long enough. The Financial Privacy Act of 1978 is what is referred to often as the initial centerpiece of federal statutory regulation of individual privacy. And it was basically to protect rights against the government. And it prohibits disclosure to the federal government of customer records held by financial institutions without notification to the customer whose records are sought, and the expiration of a waiting period. So if the government wants records from basically a financial institution, there has to be this notification given and an opportunity to, essentially an opportunity for the customer to object to this disclosure. But this only covers disclosure to the federal government, not disclosure to state or local governments. And the coverage is limited to banks, savings banks, certain credit card issuers, and industrial loan companies, etc. Customers considered to be an individual or partnerships of 5 or fewer individuals. So that was sort of the initial, beyond the Fair Credit Reporting Act, that was the initial mainstream sort of give you an opportunity to opt out of the disclosure of that information. Next slide. The Bank Secrecy Act, this is one of the ones that I told you about that is sort of opposite of the privacy rights. This has evolved, of course, into, it's the BSA AML statutory and regulatory framework that is designed to prevent the secrecy of certain financial information, at least with respect to certain individuals, by requiring financial institutions to maintain records and submit reports that can be used in investigations, including income tax evasion, illegal drug activities, insider trading, and other activity. And it's been amended several times: the Money Laundering Control Act of 1986, the Annunzio-Wiley Anti-Money Laundering Act of 1992, the Money Laundering Suppression Act of 94, and of course the most notable is the U.S. Patriot Act of 2002, and also the National Defense Authorization Act for fiscal year 2021, which includes also additional money laundering provisions designed to modernize AML and the counter-financing of terrorism law. So that law and that body of law and regulations there's a tension there between that and the privacy laws. Next slide. This is the IRS code provisions. I'm not going to go into that in depth because I don't have enough time to do that, and I want to cover some other things, but just know that there are provisions in the IRS code which basically require notice and opt-out. Next slide. The Electronic Funds Transfer Act also has, I'm not going to spend a lot of time on this, but it also has some limitations and protections on privacy, and it's important to be aware of that, and requires advanced disclosure of the privacy policies to users of of systems that employ Electronic Funds Transfer Act. Next slide. A number of computer privacy laws. I've listed them there. These are designed basically for the protection of rights to privacy in your computers. The Comprehensive Crime Control Act of 1984, the Computer Fraud and Abuse Act of 1986, basically the Computer Fraud and Abuse Act amendments of 1994, and the Electronic Communications Privacy Act of 1986. So these slides will all be available to you, and you can go into the details of it, but I'm not going to go into the details of those because I want to move on to get closer to some of the California ones in the time that I have. Next slide. This is the federal financial privacy law. As I said, this is really truly the centerpiece of regulation that pretty much covers most of our members. It's the most comprehensive financial privacy law of any of the federal legislation ever enacted. And there are basically two components to it. There's the privacy provisions, which provide for notice and disclosure, and then there's certain data security provisions designed to basically provide privacy protection at the time of establishing a customer relationship and annually during the life of the customer relationship, even if the institution does not disclose information to anyone other than their affiliated parties. And these are the things you're most familiar with, basically the privacy notices that have to be sent out, the GLB notices on a periodic basis. Next slide. There's also a broker fraud law. I'm not going to get into that in detail, but it's part of the GLBA and designed to prevent abuse of access that people may get to privacy information and then pirate it out and sell it out. So that can have significance. I think you'll see in connection with the UDAP provisions and actions that are being taken by the FTC, that could have significance there, because if you have access to it and you sell the data, then there's liability associated with that. Next slide. These are the data standards that are in the GLBA, Federal Financial Privacy Law, and in that regard, the law directs applicable federal regulators to establish appropriate standards for financial institutions for administrative, technical, and physical safeguards. And then I list there to ensure the security and confidentiality of customer information, protect against anticipated threats, and against unauthorized access. And these are all implemented by the various regulations. The important part about this, and again, I can't go into too much detail on this because there's so much that has to be covered, but the key part is the amendments in 2021 to the security guidelines, which are referred to as the safeguards rule. And there are some provisions of that are much more particular and specific than have previously been, that were previously in place. So next slide. Before I get into those data security standards, I'm not going to spend too much time on it. I just wanted to make this point about data protection laws. This is kind of an inflection point of the regulations that has occurred. Basically, what's going on with data protection laws is that there's much more emphasis now on just a broad spectrum of data protection as opposed to individual privacy rights. And much of the legislation and much of the things that are going on right now are for the protection of data and the respect of the sensitivity of data, and not just particular individual privacy rights. And so that's critically important, because some of it may or may not be private, but basically the direction that things are going is that everyone's data is private, it is sensitive, it needs protection. And that is reflected in the latest safeguards rule. So if you go to the next slide. These are some of the elements of the FTC safeguards rule, and that I've just summarized them here. Access controls to permit customer data access only to authorized users, encryption, multi-factor authentication, secure disposal of customer information within 2 years of the last use, monitoring and logging of activity of authorized users, detect unauthorized access by such users. Those are some of the center provisions of that. Next slide. And then there is reporting associated with it, and an expanded definition of financial institution. But basically, and this includes sort of trying to reach fintech entities there. And there are exemptions from certain requirements for smaller financial institutions. And that's an important exemption for some of our members. So we should be aware of that. That rule was effective on January 10th, 2022. And there are more stringent requirements that go into effect on May 13th. And some of the other panelists may talk about those. Next slide. The state financial privacy laws, again, we don't have too much time to go through all of this, but essentially there's many of them that track the federal laws. Some of them are even more specific, and in our case in California, that's certainly the case. So next slide. California Privacy Act of 1967, that's a penal code provision. Basically, it's sort of against non-governmental wiretapping and interception of cellular phone calls and that sort of thing. That's sort of one of the initial ones. Next slide. The California Information Privacy Act of 2003 basically extends beyond. It's similar to GLBA, but it puts more protections on there and extends beyond those protections. Just wanted you to know it's the same kind of opt-in, opt-out, but in this instance, basically it requires the consumer to opt in before disclosure, third-party disclosures, rather than requiring them to opt out. And that's significant, obviously, because it puts a burden, and there's some pretty detailed provisions on that require how that notice has to be given out. Next slide. SB 27. This whole, which is now enshrined in Civil Code 1798.83, if you want to look for all of these privacy protections, they're all in that Civil Code section 1798, various provisions of that, and they're all lined up in there. This one was effective in 2005, and basically it was designed to handle, again, the disclosure of customer information to third parties and how that must be protected. Next slide. The California Online Privacy Protection Act 2003. This one is sort of a computer privacy statute, and it's designed, again, to protect personally identifiable information. It's become kind of superseded by some of the other statutes, but it still exists, and it's in the Business and Professions Code. Next slide. The SB 1386, which is also in 2003. This is the state law that protects against data breaches, the cybersecurity protection, so that anybody that conducts business in California and breaches, there's certain notice requirements and everything associated with that. Next slide. That continues on. Next slide. California privacy laws. California has its own safeguards law. And so just be aware of that it's similar to the federal one. You just need to be aware of it. It's found in Civil Code 1798.81.5. Next slide. This is the California Consumer Privacy Act that was initially put in place in 2018. It's been amended, and we just I don't have time to get into the details of it. They're laid out there for you. And just be aware that many of our members are probably exempt from that. There's an exemption. There's a GLBA exemption. If you're obligated to comply with GLBA, then there's an exemption from that. And there's some rules that are kind of sophisticated and fuzzy about with respect to who can sue and who can't. But just be aware that if you're a mortgage banker and you have to comply with GLBA, you're probably not going to have to comply with most of the provisions, if not all of the provisions of this provision. Of this statute. Thank you. Next slide. Let's go on. Keep going on, Susan. One more. We've got a number of legislative initiatives. Go back one slide. I've just listed them there. I'm not going to go through them because I'm out of time, but wanted you to see that they're there, and we're dealing with those as an association. Also, next slide. There's UDAP enforcement activities that are going on, and one of them that I highlighted was this FTC action against mass data collectors, and that's significant because you can really see the shift in the regulatory attitude that what's going on here is to protect data. Next slide. Next slide. Next slide. Oh, that's my conclusion. I did want to make that point in conclusion. I'm sorry, I got ahead of myself. As these actions underscore, the FTC is committed to protecting people, and browsing and location data are sensitive, full stop. This is, again, a regulatory attitude that says, you know, any kind of the data about your personal activities is protectable, and you need to protect it. So sorry for the length of the slides, but you can go back and get more detail later, and I wanted to thank everybody for the opportunity to make this presentation. Thanks.
Okay, and with that, thank you, Michael. I appreciate it. With that, we will turn it over to Genevieve to go through regulatory privacy priorities.
Sure. So we're going to talk first about the state's priorities and what they're focusing on. We'll hit a little bit on what the FTC is looking on, and then wrap up with some of the recent statements from Chopra coming out of the CFPB. And really, the takeaway, I think, is going to be how they're all working in concert and trying to increase working together going forward. So you're seeing a merging of what all of their priorities are. So one of the things that we're seeing across a lot of the state laws that have been coming out, and then therefore into the regulators that are enforcing those laws, is a look at data minimization. So if we look at California, for example, if you don't disclose a purpose for your use and collection of data, then you're not allowed to use that data for undisclosed purposes, right? There are some minor exceptions where you can look at, well, is it compatible with another disclosed use? Would a reasonable consumer expect that you would use this information in this way, right? So there's a little bit of gray wiggle room that can happen in there, but for the most part, you really need to be specific about what it is you're collecting, how it is you're using it, and you're going to be tied to that, right? This also goes to the new requirements that you're having to tell people, this is how long we're going to keep your information, or at a minimum, this is how we're going to decide how long we're going to keep your information, okay? So you're having to start to incorporate some of that into your privacy policies that you put out into the world. The issue with that is that if you're putting it out into the world, you're now making it, in essence, a promise, right? I promise that I'm only going to keep X, Y, Z data for 5 years or 7 years or whatever the retention period probably is that you need to retain that to defend yourself from legal cases or to comply with the law, right? Okay, but the reason that this is being done is because businesses have historically been very loath to get rid of their data, right? I always tell people, like, you need to Marie Kondo your data. You need to think of it in that way. If it does not spark joy and that it is not doing something particularly useful for you, maybe you shouldn't keep it because it's a risk. And that's what the regulators don't like, is that you are keeping tons and tons of information that may not be particularly useful, but it's sensitive. And that creates a risk when you have a hacker come in and steal data out the back door, you have a ransomware attack come in, whatever it is where this information is being wrongfully obtained. So they're trying to combat the security risks that John's going to talk a bit about and how to prevent those by the forefront of saying, businesses, you need to get rid of your data that you're not using and reduce risk in that way as well. So this is something we're seeing across state privacy laws, and it's also something that we're seeing at the federal level as well. The FTC is really focused in on this as in their enforcement authority too. Go to the next slide. There we go. So you'll see actually along this line, the new privacy agency in California, they actually just issued their first ever enforcement advisory. And in doing that, they made some statements. They said, first of all, data minimization is a foundational principle of the CCPA. It applies not only to the data that you're collecting and using as you go about your normal days in business, but it also even applies to what are you collecting to be able to verify a consumer who's making a request under California's law, for example, right? So you can't just request everything under the sun because you think that sounds like a good idea. What you're requesting needs to be reasonably related to the sensitivity of the information that you would be producing in response to the consumer request, right? So fortunately for the people on this call, because the information you're generally in possession of is going to be pretty sensitive, and you want to be sure that whoever it is you're turning it over to is actually who they say they are and that they do have a valid right to have this information, you can probably step up what it is you're asking people to provide you to verify their identity, not only for the subject consumer, but for the authorized agents as well, right? But if the information that you are going to provide in response to a consumer request was far less sensitive, you wouldn't have those same protections and you would need to be ratcheting down what it is you're asking for. So again, it's looking at what are you collecting? Do you really need it? How long are you keeping it? And all of this is going towards reducing a risk. It's also going towards reducing a burden. They don't want you building in a ton of hurdles to consumers being able to exercise their rights under these laws. Next slide. So the other area that we're seeing across most of the various state laws right now, and one of the things that California has really been working a lot on, is the tracking of consumers across the internet for targeted or cross-contextual behavioral advertising. So we're going to talk in a minute about some of the enforcement actions that we've seen out of California, and we'll see how this tied into those priorities that they have there. But the right to opt out of this type of collection of information, the tracking across websites for targeted advertising, is something that we're seeing consistent across all of these state laws, right? So that tells you that they're all thinking about it, they're all focusing on it, and they're all talking about it to each other, right? That's one of the things that's going to become evident is the level of communication that's going on between the various state regulators and then also their counterparts at a federal level. So in California, as people are probably aware by now, right? Oh, you can go back on the last one first, just one more second. If you, for example, running a Metapixel, Google Ads, whatever that type of a tracker is on your website, and you're a covered business entity, you have to allow people the right to opt out of that type of data collection and disclosure down the chain, right? A sale or a sharing. You also have to honor global privacy control signals, which is a universal opt-out regime that people can set at a browser device level to communicate to the websites that they visit. So right now you have DuckDuckGo, Brave, and Mozilla, who are browsers that have this functionality built into them, but they don't have the market share for what people are actually using, right? Like most people are using Chrome or Safari or other browsers. And so there's actually a law pending or a bill pending in California right now, AB 3048, which would require browsers to, instead of me having to go get an extension to add it to Chrome to effectuate my GPC signals, Chrome will just have to provide that as an integration into its settings. So you can see they're trying to make this easier and easier for consumers to be able to exercise their rights under these laws, especially on the areas that the regulators think are really important. Okay, so now we can go to the enforcement actions. So sorry, there's a typo, the 2022 Sephora should not have been on there twice, but it was too late to fix it by the time I saw it today. So up to 2020, right, before CCPA became effective, what we mostly saw in enforcement actions in the privacy space in California was really looking at data breaches, right? Was there some sort of egregious behavior or something that really went wrong that caused or led to the data breach, right? So there were some really big ones that we've had over time that the regulators got involved in. But then once CCPA came about, we started to see a shift. So it's not that they're not still doing data breach investigations and regulatory actions, but they've switched gears. Sephora was the first public enforcement action that came out of the AG for CCPA. And really what happened was Sephora under GDPR, right? So in their international part of the website, they were honoring people's right to opt out, to not be tracked, right? It's a little bit different how that regime works in Europe, but same basic principle. And so they were honoring it in GDPR, they were not honoring it in the States. And they said, well, we don't think that the targeted advertising therefore equals a sale, right? That was the conclusion based on the decisions they had made in their website. And the AG's office wanted to make it very clear that they think the disclosure of information through targeted advertising, through those pixels, those cookies, those trackers on your website, they do count as a sale, and that you have to provide an opt-out, and that you have to honor the global privacy control signals, right? So that was the first time that we saw that in an enforcement action. Then we had Google, and really what happened in Google was that they said, Google, you're not being truthful with consumers. The way that you've set up your disclosures, if consumers set settings X, Y, and Z, they think you're not tracking their location anymore. That's what a reasonable person would think. But what's really happening is you are still tracking, right? So again, it's this misrepresentation. You've made these public statements in your policies, your terms of service, your settings, and they're not actually true. And so we're going to hold you to what we perceive as the misrepresentation. 2024, the types of online advertising that the regulators are going after, it's a little bit more complicated. And one of the things that you'll see is that not only at a state, but at a federal level, the way the regulators are staffing is they're not just hiring lawyers to come in and handle these types of matters, they're handling technologists. And the head of the California Privacy Agency, that's what he was. Like, he was a technologist. So they're hiring people to come in and explain to them how SDKs work, right? They're basically bringing experts inside to help their lawyers to more effectively prosecute these cases. And so what was happening in DoorDash was you had a unique consumer who, to avoid advertising and being targeted and blasted emails and whatnot, she had created sort of I think it was a false email address or something. Not false, I mean, it was real, it just wasn't her normal one, and she only used it for DoorDash apparently. Well, all of a sudden, the information that she'd only entered into DoorDash, she was getting targeted from other places. So she knew DoorDash was sharing and disclosing this information in some way. And what happened was that there was a marketing co-op in which businesses were swapping consumer information back for advertising purposes. When the privacy agency approached DoorDash tried to effectuate the opt-outs, they tried to stop their disclosure of information. It wasn't enough. It wasn't, in essence, it wasn't a cure. They weren't able to put the genie back in the bottle, was what the regulator said, because you couldn't stop and pull back that her information had already been disclosed down this path. And you couldn't pull it back from all of the data brokers and other advertisers that had already accessed it. And so that was where the harm came for her. So it's a bigger, more long-term picture about what your obligations are. So it's not just you that has to opt out. You need to make sure everybody else down the chain is opting out as much as you can too. Okay, so next slide. So just to give an idea of how the AGs are working together in these state collaborations, just you guys can already read them to you, but here's a list of businesses that they've been going after for whatever the violations are, right? And these may not all necessarily be privacy violations, but I just want you to see the point of the AGs are working together to go after very large, big targets. And it's not specific to any one industry, right? So it is really varied, and they're pooling their resources so that they can really take on these large results that they think will benefit consumers in a very large geographic area. Next slide. So the FTC is also collaborating with some of the state AGs, and they actually issued a report earlier this month to Congress, and they lay out, here's all the current ways that we are working with the state AGs, here's our recommended best practices to enhance collaborations, and here's our legislative recommendations to enhance collaborations. Granted, there are some subtleties and some nuances and some differences between kind of 1, 2, and 3. Frankly, from a very high level, they read very similar. And the point is, we need to continue to collaborate, to pool our resources, to work together, to share information over and over again. So we're doing that. We're going to continue to work on it. And Congress, we want you to help us be able to do it even better. That was the pervasive message throughout this entire report. Next slide. So the Federal Trade Commission itself, it has its own some sets of priorities here. You can go forward. So there's actually, the FTC was recently, it was like a year ago, was part of a 4-agency coalition. The EEOC, FTC, CFPB, and the DOJ. And one of the technologies that they were talking and looking at across all of these agencies was looking at artificial intelligence, right? This is the topic that everybody loves to talk about these days, is AI and machine learning. And what the point and really the takeaway of this coalition and the statements were is saying, we understand that these technologies are out there. We understand that they can have benefits. However, let's be clear. These technologies do not get any business out of their legal compliance obligations. So you still have to comply with all of the laws, whether or not you're using this type of technology. And the reason being is that this technology can have very significant impact on housing, employment, credit, goods and services, right? And all of those key things that matter to each one of us as a human as we go about our life, right? That we need and want to be able to have fair access to. And so what they're trying to look at is how do they go about balancing the potential harms and bias with the advancements and the benefits that these technologies can have. And they're trying to really focus in on using both education and enforcement to achieve their goals. And they're even looking at employers, right? So this is a big part. You have a lot of big companies that are scanning resumes to decide. They just use an automated scanner. Are you even going to get an interview or not? Right? Do you even get called in? So now you have all these consultants that are, you see them on LinkedIn all the time, right? They're out there saying, we'll revise your resume for you so that you get just the right keywords in them so that the AI system that's scanning your resume will pick it up and throw you in the good pile, right? And so, but what if you are an individual who has a disability, who's going through this application process that you've asked for some sort of an accommodation, right? Your obligations as an employer in dealing with accommodation requests or how you handle that application for a person with a disability, you're not excused from those just because it was running through your AI. You have to have a way to be able to still deal with those legal obligations. So I think that was one of the prime examples that they were focusing on and looking at. Next slide. And this was what Michael was talking a little bit about with the location, right? That the FTC has been doing a lot of activity on. They've had a lot of consent orders. They're litigated up in Idaho in the Kachava case. But there's a lot of look at geolocation data in general. And how specific is it? How can you tell where people are located, right? And the issue is we have our vehicles, which you see a lot of now manufacturers are being sued based on how they're disclosing the telematics out of your vehicle that tell everywhere you go, right? Like your Tesla remembers, or your GPS is like, oh, did you want to go back to this spot every day at 8:30? It looks like you drive here. Let me suggest it for you, right? It's all being captured in your vehicle. It's basically a computer on wheels, and we all carry our cell phones everywhere we go. And so between those two, there's a ton of geolocation data that's feeding back not only to the manufacturers and the finance companies associated with the vehicles, but also potentially to all of the apps that are on your phone. And think about like your safety, about where you go, or your privacy, about the doctor's offices that you go to, or the places of worship that you go to, right? So your geolocation data is really sensitive because of all of the inferences that it can provide about you, about your life, to profile you, etc. And so what you're seeing is the regulators try to go after the collection and the sale of this data. They don't want it just being sold willy-nilly across data brokers. They're trying to stop that and cut that off. One of the things that I think is interesting, and it's being a little mixed and matched, maybe a little bit apples and oranges in the conversation about geolocation data, is sometimes the regulators are conflating them, and sometimes it's true, right? Maybe where my vehicle goes all the time is where I go. Maybe there's other people that drive my car all of the time. Maybe we switch drivers all of the time. Maybe I financed the vehicle and its registration, but I have an au pair who drives that vehicle all of the time, right? So the geolocation of a device, not necessarily the geolocation of an individual, quite often, but not always. But that's something I think businesses are going to have to dive into and take a deep look at when they're looking at how to defend themselves and deal with some of these regulatory investigations that are focusing in on geolocation. Next slide. And so Michael briefly mentioned as well about the new proposed, I think, the American Privacy Rights Act. This is the federal privacy legislation and bipartisan that is up at Congress. Just a few things to note. So right now, the way that it's set up, it would be a ceiling, not a floor, as far as preemption goes. Not a surprise, California regulators adamantly oppose that provision and the preemption, and they've already been making statements. They went up against prior federal bills on the same issue, and they've already made public statements. They're going to continue to fight and push at the federal level to have that part changed. There are some carve-outs for biometric and employee data. The other not preemption, but exemptions that would be applicable to the folks on this call really are not only the employee data portion, but the way that the GLBA exemption is set up, it's a lot more like California than it is like Colorado, Utah, or Virginia, right? So a lot of those other state privacy laws have said, if you are a GLBA regulated entity, sort of presuming you're complying with GLBA, I think is what's embedded into those, then as an entity, you're exempt from the state law, right? Whatever the specific regime is. California didn't do that. California said, whatever data you are handling, collecting, and using pursuant to GLBA is exempt from most of the provisions in CCPA, right? But not necessarily all of them. And not all of the data that you possess is GLBA data. Just because it's an entity level, you might be complying with GLBA. So this federal law would follow much more of the California style data level exemptions, and it would blanket that across the country. So that's an interesting dynamic, I think, between the nice carve-outs that GLBA entities were obtaining in other states. It would take some of those away. Also, just heads up that Oregon's going to have a similar, slightly different, again, data level analysis going to happen when Oregon rolls into play. On the private right of action and enforcement on that really quick, back just a note that it can be enforced at many levels, right? So not only would the FTC have some very specific obligations under this law, they would be required to build up an entire department focused in on enforcing this law, but state AGs, and then also it would have a private right of action. So a lot of the litigation you see in California, you would see it much more broadly across the country. All right, we can scoot on over to the CFPB. So Chopra has made some statements recently. In March, he sat down with the Attorney General Alliance Chair, Aaron Ford. They had a nice fireside chat, and they talked about several things. Really, the big takeaways were the CFPB and the state AGs need to continue to work together. And then he laid out some of the ways that the CFPB can help the state AGs. For example, they are encouraging consumers, if you have a complaint, make them in both portals, because the CFPB has methodology set up to scan and evaluate the incoming consumer complaints. They can look at them for hot topics in specific geographic regions, and then they can work with the AGs and provide them with that data to help them decide where they want to funnel their resources, what's actually impacting consumers negatively in their area. And also the way that the CFPB, as you all know, the portal is set up, it automatically generates an inquiry out to whoever the relevant financial institution says, and like, we got this complaint, please respond, give us all your position in response to it, right? So that's happening on a much more of an automated fashion, I think, at the CFPB level than it is at the state AGs. So basically, he's offering up their services and technology to help the AGs. And then again, you see the focus on the data brokers, that they're really not comfortable with the data brokers. They're repeatedly, regulators are trying to build in registries and give people single opt-out kinds of spaces that they want to use the FCRA, for example, to continue to combat data broker issues. And then again, that they also are hiring technologists, so not only for enforcement, but on the investigation side of things as well. And then AI, everybody's focusing on AI. And the next one. And then the next, or a couple weeks later, I guess it probably was, Shukrov was over at IAPP. And again, he repeated some of the same basic goals. He did talk a little bit more about the open banking that's coming, and sort of the financial privacy laws, which will be interesting to see how the financial institutions go about exchanging data with each other and releasing it to consumers, and what kind of security issues are going to come into play for that. What I think is interesting in the way that, and maybe this is a little bit part of a pendulum, or just that Europe is a little bit farther ahead in that they've had GDPR enacted for a few more years. But right now you see a lot of effort in the US about how do we rein in data brokers, right? How can we keep consumer information protected and not have it widely sold and distributed? Just like a juxtaposition to that, the Financial Conduct Authority, which is a regulator over in the UK, they came out on Monday saying, we're really interested to see and to run a pilot program on how big data, so specifically looking at businesses like Google or Amazon, how the information that they have could be valuable in the retail financial markets and might actually be beneficial to consumers. And so I don't know if it's, maybe there's just somebody who had a wild hair over there and that they're trying to figure out this new program. I don't know if it's that they've had better luck in reining in data broker type situations, and so now they're looking at, okay, of the information that we've allowed to be collected that we think was okay to be collected, how can we use that in a way that's also helpful to consumers? So I just think it's interesting they're in slightly different spots here as we go forward. So with that, I'm going to turn it over to John, because I know we're running behind here.
Okay, Genevieve, thank you so much. Great presentation. Yes, John, we'll go ahead and get started with your presentation.
Thank you. I'll see how I can condense this down to several minutes here. Great presentations by Michael and Genevieve. They touched on many of the pertinent points. Michael highlighted so many of the laws, and Genevieve talked about the various ways of action that can be taken upon this. What I'm going to look to discuss quickly is, how does this impact you as a state-regulated non-bank financial institution, as a critical vendor to non-bank institutions or banking institutions that hold consumer data? And what I'm going to really look to drill down on is basically the elements that state regulators are going to start looking at in their examination of licensed organizations, and what this governance program that you created needs to contain, entail, how you're going to provide that information, and how you're going to defend against potential claims by regulators of insufficient security and data protection practices. So next slide, please. From a very high level, if you are a covered institution subject to CFPB oversight, obviously the CFPB has direct regulatory authority, examination authority over you. In 2022, Director Chopra went even further in formalizing what I'll refer to as a deputization of state regulators, meaning effectively that the CFPB and Congress, and through the rule created by the CFPB, state regulators have the ability to enforce federal law. So while we might have heard there might exist exemptions from certain state data privacy obligations because you're subject to GLBA, that doesn't get you off the hook. That just means that these state regulators either working independently, collectively. State regulators like to work in consortia at times to bring enforcement actions on a regional basis, or hand in hand with the CFPB. They work directly with the CFPB and effectively working as eyes and ears on behalf of the CFPB. So state regulators can enforce the GLBA provisions. What I'm going to focus on are the safeguard elements to that, primarily as it relates to your corporate network and security protections. So don't think for a second that you're going to be off the hook in any regard. Your state regulators are going to ask for advanced documentation of your cybersecurity governance and your data privacy program. The better this documentation that you can provide in advance, the less likely you're going to have as invasive of an examination going forward. While this might be kind of foreign, low-level file review and walkthroughs might be what you're used to by your state regulators. You can now include cybersecurity and data privacy governance as part of these examinations. So, next slide, please. Effectively, the first thing you should be looking to having in place is an effective governance program. Your cybersecurity governance program must address how your corporate network has the requisite protections to ensure that data is maintained in a secure way. And I know it's a very, very broad term. A lot of you might have on-premise technology stacks where you've got that giant room with no windows in the center of your building with a lot of fans that emits a lot of heat, right? You might be maintaining your on-premise corporate network. You might be using AWS, Azure, Google Cloud as a infrastructure as a service where you might host your corporate network or elements of it. So if you have part of your network in that server room and part of your network on the cloud, you have a hybrid infrastructure. If you're only on AWS or Azure, you've got an exclusively cloud native infrastructure. So the regulators are going to want to understand first and foremost, how does your corporate network exist? Where does it exist? Secondly, they're going to be looking to where are your employees? This wasn't that big of a deal prior to 2020, but now we live in a world where there's a significant amount of remote working. And they're going to want to see that you extend access to your corporate network to your employees in a safe and secure manner. You're going to have to use terms such as, you can hear terms such as VDI or VPN, effectively means of securely and uniformly delivering corporate network experience to your employees who might have corporate issued computers, who might have their own computers. These are called endpoints, and a big concern will be called is referred to as endpoint management. You're going to have to establish how you protect your corporate network from the points in which your employees access it. Also, you might bring in third-party technologies. This is a very large part of your governance program, is how you oversee your relationships with third parties. We like to call them vendors, LOS, POS, NEQC vendors that effectively you provide the consumer data for which you're a custodian of for the provisioning of certain services. Your obligations to oversee what they do as either a mission critical element, right? That's an LOS and a POS are pretty mission critical. Without them, you can't conduct day-to-day business. And ensure that these third parties who take possession of this data off of your network and onto their network have the requisite controls to protect that data in a manner that you are responsible for. So I hear a lot of times, well, the vendor says that they're not directly regulated. Well, that doesn't matter. The vendor doesn't have to be directly regulated to be culpable. What they have to do is they have to understand their client base. They have to understand the regulatory obligations of their client base. And a vendor has the wonderful obligation of understanding all of the regulatory obligations of the various client base, whether it be a credit union, a federally chartered bank, a state depository, a state mortgage banker, a state broker, a servicer. Effectively understand what those obligations are and provide the same protections for which the financial institution is held accountable for. And that's done through, effectively through vendor management program, which includes your licensing contracts and reps that they need to make for security, as well as data protection, and your oversight, effectively not taking their word for it and not taking their reps, but ensuring that they have the same controls in place that you're being held accountable for. You know, the requisite malware, the same endpoint management, the same firewalls, the same perimeter monitoring. So you have to understand how your vendor's corporate network is set up and delineated. You need to document this, and you need to, on an annual basis, re-review it with all your vendors, and then show your regulators, whether it's CFPB or the state regulators, how you do this, to what extent you've done it, and not only how you keep yourself accountable, but how you keep your vendors accountable. That is an area right now that's really overlooked. And when you, as a regulated financial institution, lose exclusive control of your consumer data, you need to be sure that those proxies that are a custodian of it for a period of time, hopefully not too long, are responsible for it in the manner that you're responsible for it. Next slide, please. These are some key elements to what your governance program needs to address. You know, as part of your governance, I would recommend, as a financial institution, you have a chief information security officer. This is going to be a question. Do you have a CISO on staff, or do you have a responsible individual who's accountable for your infrastructure technology controls and data privacy controls? If you do not have a CISO, you can act in conjunction with certain managed service providers that can contractually provide you with CISO as a service capability. You can work with external counsel who can empower an internal responsible individual with the requisite information and knowledge on what to do and how to conduct this responsibility. So it's vital that you have a person responsible in your institution that understands everything I mentioned earlier. Your risk assessment and management program, identifying, evaluating, and prioritizing risk in your institution and that of your vendors. Asset management. You know, how do you obtain servers if you have an on-premise technology? How do you obtain the servers? Where are they coming from? You know, a lot of servers and switches are penetration vectors for nefarious third-party nations who might have backdoors or side doors into your infrastructure unknowingly. So you cannot just buy hardware haphazardly. You've got to obtain the hardware in a responsible manner. If you provision the IT stack through cloud providers such as AWS or Azure, that comes with a certain level of confidence in the compliance of the infrastructure, but not a full comfort level. Cloud providers do not address all of your compliance needs, even though they might offer you a SOC 2, which I see a lot of people saying, "Why? Oh, AWS gave me their SOC 2." That's great. That's great. You know, you have a house and they're attesting to the veracity of the house, but you're responsible for the security of the doors and the windows. So it's called the shared responsibility or shared compliance responsibility model with AWS and Azure, where they cover certain things, but you have to cover certain things. And those certain things that you cover, you need to prove to third parties such as regulators what it is you control, how you control it. First thing is asset control. That's what we talked about earlier. How do your employees access the system? Do you use password? Do you have password protections? Do you rotate passwords? Do you force, do you have complex password obligations? Do you use multi-factor or two-factor authentication? Do you use, ideally a biometric methodology in addition to, as part of your multi-factor authentication? Do you have role-based controls when you set up employees to your structure? Are you sure that the processor doesn't have access to the CFO's files, right? That you need to be sure that based on the function and the role of the individual in the organization, that their controls are managed by you, and you set the controls to say, based on who you are and what you do in our organization, we determine what access you have to what sections of our infrastructure. You know, historically, I always say, think about walking through an office where you have a file room, you have a server room, you have the C-suite locks all their offices, and you have the one person with that giant keychain with emergency access to all those rooms. It's the same thing exists in the virtual environment. You have to ensure that each of those filing cabinets in each of those offices are effectively locked off from people that should not and do not need access to it virtually. Those are access controls. Data protection, obviously, how do you protect your consumer data? Encryption is a big term of art. How do you encrypt data when it transfers from one place to another? If you have an offsite web-based LOS, and you have a graphical user interface, you know, do you control the pushing of the data between the two disparate data centers, and encrypt the data in transit? You know, when you save that data in your virtual storage or your X drive or wherever it might be as it presents on your computer, is that data as it sits on the infrastructure, is that encrypted? That's encryption of data at rest. These concepts need to be elaborated on. And obviously physical security. Long gone are the days of just badging people and using badge controls to access the office in and out. You know, there are a significant number of additional physical securities obligations that you need to maintain. Next slide. In addition to shredding bins and logging visitors and badging. Operational security, basically, every time you provision new hardware, you bring on a new software provider, do you understand what they're doing? Do you understand their controls? Do you maintain? Do they require maintenance? Does the responsible individual in your organization understand that you need to keep an eye out for patches or software enhancements? Software might not be always web-based and web-delivered, where enhancements are automatically presented through the web-based software. You might have the software on premise where then you have to receive, you know, a pushed code, and that code has to be spun up and placed into your infrastructure, and your software needs to be patched. A lot of vulnerabilities in organizations exist through the failure to timely apply patching. And we live in such a timely, a dangerous world where exploits can be found, and within hours, nefarious actors can be attempted to exploit these known areas. And if you don't timely patch your software, you're effectively leaving your front door open for third parties to enter and potentially see and exfiltrate consumer data. Incident response and recovery. You might have a virtual infrastructure. You might have a, you know, an LOS that is web delivered. You know, in the event something goes down, something fails, technology is going to fail at any given point. It's not impervious to failure. Your obligation is to be sure that you've got a recovery obligation, a recovery ability, something or a replication of your working environment. So if one environment goes down, you can point to your employees to another environment. So there's not a lot of lost productivity. There's not a lot of lost data. And most certainly, if you're delivering services to consumers, there's no interruption in your ability to deliver services. Regulators are going to want to see how you respond to catastrophe. What is your business continuity and disaster recovery program? No longer business continuity means, all right, everyone in this office, if it's flooded, goes to this office. Think of it, technology in the same way. If this technology doesn't work over here, this technology immediately picks up and provides access. So business continuity, disaster recovery is huge. Employee training and awareness. They're going to want to see how you make your employees aware of potential threats. Phishing, social engineering, I think everyone's pretty familiar with now emails that come in and ask you to click on a link, and you spin up a malware within your infrastructure because you clicked on a link. That malware might brick your infrastructure, basically lock down and keep you from doing anything. In ransomware, everyone hears the horror stories. That's a big penetration point for ransomware. They lock down your system, ask you for a lot of money to release access to your own infrastructure, again, so you can continue to conduct business. You need to train your employees on how to spot emails that aren't true, not receive emails from untrusted parties or unexpected emails. Training and awareness is perpetual. It's continually going, and it's continually evolving. So you need to have someone responsible for staying abreast of the latest trends in social engineering and third-party penetration. Third-party security, we talked about that a lot. Compliance legal requirements. Were you paying attention to Michael and Genevieve when they talked about what your obligations are? What are your obligations? Who are you? Based on who you are, what you do, where you're licensing, who are you regulated by? Those will delineate your obligations. GLBA is a good place to start. Pretty much everyone on this call has some obligation to GLBA in some form or other, either directly or indirectly. From there, it depends on states, depends on certain services that you provide. Continuing keeping your documentation up to date, that's a no-brainer. Emergency contacts, communication channels. What do you do if you're penetrated? If you are blocked, are you a publicly traded company? Do you have an obligation? You are on the clock once you have notice of a breach to the SEC. You have a certain time frame to identify, to deliver information, say we were penetrated, we were delineated. You can't hide behind the walls, figure out to what extent, and we'll do some investigation. That takes months. No longer. You've got to immediately notify, whether it's the SEC or now even state regulators are mandating response times for breaches and any major cybersecurity incident. So you need to have an incident response plan. What happens? Who do you call? What do you set into motion? Your incident recovery and response, and your notification, and then your forensic team. Somebody saying who got in, where did they get into, what did they look at, did they take anything? Simple questions. Next slide. Data privacy concepts are very much the same. I always use the metaphor. Cybersecurity is think of cybersecurity as the house. You've got a secure brick house with a brick roof. You're responsible for controlling, the windows and the doors. You put your alarm system on, and you ensure that everyone in and out, is monitored. Ultimately, think of data privacy as within that house, you've got filing cabinets, you've got drawers of jewelry. How do you protect that? The data that's under your control within your secure infrastructure. What data is coming in? What non-public data might you have? What are your data classifications? You might have consumer data. You might have non-public personal information. You might have different types of different classifications. I don't think you would have any healthcare related data, but there are certain types of data classifications that you need to be aware of if you collect it, what your obligations are by the sheer fact that you house and maintain that data. Risk mitigation, obviously failure in exam will lead to fines, penalties, notification of other state regulators. If a state regulator comes in and finds a deficiency, knowledge of that deficiency might obligate you to notify an array of different state regulators, put them on notice. The one thing you can count on is the states don't want the federal government to be the exclusive check receivers from you. They want you to cut them a check as well as if you're cutting a check to the federal government. Think of it that way. So the state regulators want to be sure that they're not only protecting their consumers, but they have the ability to motivate you through enforcement actions, CIDs, or the like. Headline risk is always a fearful one. Wall Street Journal likes to cover front page information. Large mortgage lender had 100,000 files, exposed. Then they publish 3 months later what really happened and what happened at the end on the back page, but that's neither here nor there. But effectively, data privacy, again, it requires to have concepts of, encryption, access controls. Excuse me. Sorry, talking too much. Access controls, how your policies align with your compliance obligations, who's your staff, what your training is, how you communicate with your customers, etc. Next slide. Once again, these are the elements of a data privacy program. Remember, cybersecurity is distinct from data privacy. Data classification, we talked about what types of data you collect. Data collection, where it is and how long you hold it, and what was addressed before. Do you have the legal authority to hold it? Obviously, as a state regulated institution, you've got records retention obligation. That's legal authority. The legal authority for duration is how long do you need to maintain those records. That is the data collection duration authorization. What are you using the data for? You get these contracts from vendors that say they want to use your performance data and potential consumer data for aggregation and reporting, but they are going to de-identify it, or they're going to anonymize it. Do you understand the difference between de-identification of data and anonymization of data? A regulatory obligation says you must anonymize the data, but if the contract says that they de-identify it, that's not sufficient. De-identification means that they can decrypt it and take it apart, fragment it, but they can put it back together. True anonymization, you can't put it back together. You're taking out all the non-public personal information in perpetuity. So you need to understand the reps and warrants that you get from your vendors and that you make to your investors and your third parties on the use of the data. Data sharing, data disclosures. Once again, you share data with people that have the express and contractual authorization to obtain and retain that data. And you're going to be held accountable for mapping where your consumer data goes. It goes from here to here to here to this vendor to this vendor. And whomever might have access to that data, whether it be a subcontractor that's conducting maintenance on your infrastructure, or if it's a critical vendor or a non-critical vendor. Why are they getting the data? Do they have the authority? Show me the authorization that they have to protect that data to you and that you're overseeing it. Data access and correction. This is a big thing. The recent trend of the GDPR, Genevieve talked about from a high level, the state obligations. Are you allowing if a consumer finds incorrect information in the process of manufacturing a mortgage loan, they have a right to make the correction if necessary. This is big in the Fair Credit Reporting Act. Nobody likes to see derogatory elements on their credit report, especially if they're not accurate, right? That's now translating to data retention from a regulated institution. Data disposal. How are you getting rid of data? How long are you retaining it for? But most importantly, are you purging it? Are you purging it securely? What happens when you purge it? Is it cached somewhere? That means is it located in an ancillary system that's used for ease of communication, for quick access, like a temporary boarding area? Is that data in a LOS? Are you using your LOS as a data store of record, right? Or do you have your own data, your own data retention obligations in addition to your physical vault? You need to delineate what these retention and disposal obligations are. Next slide. And I'm running way over here. My apologies. We can get to the next slide. This is probably pretty redundant. As we talked about slightly, contracts are huge. Make sure your contracts are in line. Whether it be with your SaaS providers, your clients, managed service providers, IT staff, IT subcontractors. Are you conducting background checks, right? To what extent do you need to conduct a background check for persons that might have access to consumer data? Insurance. Cyber insurance is vital here. Not only for a regulator must you prove your ability to control and preserve data, your cyber insurers now are very much concerned with your ability to do this. And this is going to be part, if not already, of their insurance underwriting process. You may not be able to obtain cyber risk insurance if you don't have the requisite controls. This is very important. I delineated a few of the different types of coverage and the nuances of what the types of coverage are for. Make sure you familiarize yourself with these. Make sure that you have this. If you have a breach event and you're on the hook for certain costs, if your vendor has a breach, are they on the hook? Are you on the hook? Are you protected? Next slide. And these are just some buzzwords. Your responsible individual should be able to understand what each and every one of these terms mean. Each and every one of these terms have a meaning in your day-to-day operations if you use an on-premise or cloud technology. As a regulated entity, each of these words should exist in either your cybersecurity policy or data security policy. Words or concepts, these must be addressed. So I think that wraps it up for my speed explanation. Thank you very much for the opportunity, and I'll hand it back to you, Susan.
Great, thank you so much. Wow, what a great presentation, all of you. Thank you so much. I really appreciate it. And thanks to those of you who are still on the webinar. It was really, again, great presentation, something that is very important to, I know, everyone in the industry. I did drop the a PDF of the slide deck in the handout, so you're welcome to download that. We do have a couple of questions. If we can run through just two and see if we can provide some guidance. In regards to data retention, is that only relevant to sensitive data?
No, assuming that you're a covered entity under the CCPA, right, in California's law, you're supposed to put out a data retention schedule to some unknown level of specificity so far as to all of the categories of data that you collect. If that's not possible or feasible, you can include some language that describes how you go about deciding how long you're going to keep information. So try to be as specific as you can, but recognize also that the ways in which your entities, your businesses maintain data and how you think of what you're going to get rid of isn't going to correlate one-to-one with the categories laid out in the law. So you might have to shift how you discuss those.
And remember, as a regulated institution, you have record retention obligations. Those may be 3, 4, 5 years, depending on the state in which you're conducting business. That means that you have the legal authority to hold on to that data for that duration, the retention period. The questions do arise, though, after the records period of time. Must you purge those? Must you get rid of those? And to what extent can you use de-identified or anonymized data for building data models for AI? Let's talk about AI, right? And this is a real thing. How the use of this data might exist in perpetuity. It might exist in the period much longer than intended, unintentionally. So the question is, does it apply to PII only or not? The answer is that it depends on what's the purpose of the use and the retention, and whether or not there is authorization.
Okay, great, thank you. One more question. Thoughts on Cisco umbrella in conjunction with the solid asset management combined with cloud working towards ISO 27000.1.
Can you repeat that?
It's in the questions dialog box. I think if you can see it, it says thoughts on. I'm sorry, I don't have more information on this, but the question was thoughts on Cisco umbrella in conjunction with the solid asset management combined with cloud working towards ISO 27000.
Well, I could tell you ISO 27001 is a framework which you could be targeting. It's a responsible framework that it does address many of the cloud, the infrastructure related controls that you need to have in place. You know, while many of these laws that we talk about, like the safeguards rule, do identify certain elements of what a secure infrastructure is, none of these laws are in their entirety representative of your obligations. So you need to look at these third-party frameworks, whether it's ISO 27001, whether it's NIST 853, whether it's a CIS benchmark if you're using AWS or Azure. While there's no weight of law behind these, what you're going to start seeing is the reliance upon, I think NIST, for example, NIST might be the anointed one, to put forth in a manner as a SRO almost what the requisite obligations are. So I think the question is, if you're working towards 27001, that's a great target. And if you're looking to obtain 27001 as a service provider, I would absolutely recommend it. It's basically just a reflection of the sufficiency of your controls in a concise term.
Excellent. Thank you so much. Really, I'm getting a lot of comments already about how much they appreciated everyone's presentation today. So thank you to all of our speakers, and thanks to you for joining us today for our quarterly legal issues and regulatory compliance webinar. That concludes today's presentation. You can follow us on LinkedIn for more information on future webinars, or if you'd like to be added to the distribution list, you can email us at membership@cmba.com. Thank you all for joining us today, and have a great rest of your day.
Bye all.